Thank you, Mr. Rodriguez. Now brings us to item 9D. Again, we have Mr. Mark Town, Community Development Director, Dr. Jonathan Kramer, Founder, Principal Attorney, Telecom Law Firm, and Patrick Heher, Assistant City Attorney. And we will be covering urgency ordinance and resolution amending regulations and policies related to wireless communication facilities and resolutions initiating amendments to regulations and policies concerning wireless communication facilities. That's a mouthful. Take it away.
It definitely is. Thank you, Mr. Mayor. So this item does relate to wireless facility policy. And specifically, tonight we're going to be talking about new rules that were adopted by the FCC with regard to a certain class of wireless facilities. And this is set against a backdrop of 5G technology, which is the next wave of wireless technology. Right now, we're still working primarily with 4G, but the 5G technology is much faster. It enables much faster transfer of information. It has a variety of applications, including autonomous cars and so forth. Because this is and in part by design, these facilities are smaller than your traditional macro sites. They have smaller radii, about 300 to 500 feet instead of miles. And so by default, we need, or we are likely to need a larger number of smaller facilities throughout the city to accommodate this new technology. This image is one that simply shows the current 5G coverage. You can see most of it is sort of in this east and southeastern portion of the country, with spots in Los Angeles and Sacramento on the West Coast in terms of rollout of 5G. Now, currently, the city has approximately 140 wireless facilities, and I know many of you have dealt with these in the past. We have 4 primary carriers in the city, as shown here: AT&T, Sprint, T-Mobile, and Verizon. And these facilities today, they come in all shapes and sizes. They come in all sorts of locations and on new structures, existing structures. As shown here, some of the more popular locations are on buildings, electric transmission poles like the SCE lattice towers, sport field light poles, etc. And now I just wanted to take a quick moment to look at our existing wireless policies. So back in 1997, the City Council adopted what we call City Resolution 97197, which has governed the location design of macro sites and some smaller sites over this intervening period. In 2009, the FCC adopted a regulatory ruling which established timeframes for wireless facility siting, and those are shown here: 90 and 150 days. And then in 2012, FCC adopted another rule which relates to what we call 6409 projects. And basically these are modifications which in the FCC's mind are less than substantial to existing facilities, and those have a short time frame of 60 days. And we've been implementing the 6409 federal policies since they were adopted. So we're here, though, tonight to really focus on the most recent FCC rule, which is known as 18133, published last fall. And again, its stated goal is to facilitate deployment of this 5G infrastructure. And to be direct, it limits local authority over these quote-unquote small wireless facilities. And in your packet tonight, we have included some attachments which are intended just to give you a flavor of the FCC's viewpoint on 5G and how important to the FCC the deployment of this infrastructure is to the future of the country and our communication technology. So some of the items that we're going to be talking about tonight are summarized here. These facilities, they are primarily, we expect them to be primarily within the public right-of-way. Access is specifically granted in that area, although they could be outside the right-of-way as well. And we're going to talk about fees and applications, shot clocks, which is the time frame within which these have to be processed. Then we're also going to talk a little bit about aesthetic rules. Part of the FCC ruling, which again is part of your packet, states that cities and counties must be as objective as possible in terms of our rules and our standards, and those need to be published in advance so that wireless companies can understand the city's position and can design a facility accordingly. So SWF stands for Small Wireless Facility. So I'm going to jump right in terms of some of the numerical standards that the FCC has mandated. First of all, the antennas for these facilities can be no more than 3 cubic feet per antenna, although there's no limit on the number of antennas. And this image here on the right side of your screen, this shows very typical public right-of-way design. You can see the replacement light pole here, the light fixture, and then what we call a radome on top. And typically these types of designs have 3 antennas in that cylindrical structure, which if you look at the volume of the cylindrical structure is about 9 cubic feet. The equipment for these facilities has to be a maximum of 28 cubic feet. And this image on the right shows not 28 cubic feet, but it gives you an idea about the approximate size. These are not huge structures, but they obviously are quite visible if you get a number of these. And so I'll talk about this later, but why not mention it now? Our approach is that these have to all be underground so that we don't have to look at this. Now, height standards. The small wireless facilities have several structure height standards, and these are or options. So an applicant can locate these facilities on structures that are 50 feet or less, including antennas. They can be in structures that are no more than 10% taller than adjacent. And they can also be located on structures that don't extend beyond 50 feet or by more than 10%, whichever is greater. We'll see how this plays out, but for street light facilities, in general, they're about 30 feet in height, excluding that radome that I mentioned a few minutes ago. And so the facilities we have in town in terms of street light designs are currently about 35 to 36 feet in total height. Fees are actually set in large part by the FCC. They set what they consider presumptively acceptable rates, $500 for applications involving up to 5 facilities on existing structures, $1,000 for new structures, and then an annual rate for the small cell access rates. Now, this is probably the most important part of these new rules, and that is the shot clocks. These are the time frames within which we have to process these applications. So the FCC is mandating that facilities proposed on existing structures be processed, and I note this in the next bullet, they have to be processed in terms of application to building permit issuance, including all intervening steps in 60 days, 2 months. For facilities proposed on new structures, say a replacement streetlight, it's 3 months. And that's, again, application to building permit issuance. As I think will become evident in a moment, it's not practical, it's not even feasible to meet these deadlines of 2 and 3 months and go through a normal planning process. It's not feasible. This is a diagrammatic illustration, and I won't go into all of the steps, but this illustrates a typical process and potential steps for a wireless case that would go to the Planning Commission, for instance. And so at the top in the blue is the planning process. You can see it's composed of a number of steps. A number of these steps have mandated time frames associated with them, particularly in terms of public notice. And that overall process in blue is roughly about 4 months. In the green is the appeal process. If somebody appeals a decision of the Planning Commission, then obviously it would go to yourselves for final adjudication, and that is typically 2 to 3 months. And then the building permit process is about 2 months. Now, theoretically, that can be conducted concurrently with the planning process, but that's usually not a good idea because sometimes the design can change through the process. But it is an option, and it takes a couple months. So when you sum these three processes together, assuming that a planning commission decision is appealed, then you're looking at roughly an 8 to 9 month process. That's our normal approach. So again, we're mandated now to process these application to building permit issuance, including all intervening appeals, hearings, et cetera, theoretically, that type of a process has to be accommodated within 60 to 90 days. And staff has looked at this very carefully, and our conclusion is that it's not possible to meet those deadlines with our existing process, as illustrated here. So staff is recommending the following approach, and it was developed in coordination with Dr. Jonathan Kramer, seated to my left, who is an expert on wireless technology, both from a technical and a legal standpoint. So I'm glad that Mr. Kramer is here, as you have seen him on other occasions. And also, while I'm doing it, I'll introduce the other team members tonight. Patrick Heher, Assistant City Attorney, who has worked extensively on this project, and again, Jeff Spector, case planner and senior planner. Okay, back to the recommended approach. What staff is recommending tonight is basically two things. First is that you adopt an urgency ordinance with an attached policy resolution that addresses the small wireless facilities. We're also asking that it include practices basically to formalize them that staff have been using for this other class of facilities, these comparatively small changes, what we call 6409. We didn't adopt policies for 6409 after the FCC took their ruling or made their ruling in 2012. We've just been following federal law, and now we just want to formalize that practice. Has not presented issues between that point and tonight. We're also asking that you initiate a regular ordinance with corresponding policies. We've included a resolution to start that process tonight. That would go through our normal process. It would be reviewed by the Planning Commission and come back to you for final action. Okay, the urgency ordinance, it will amend the municipal code. We feel that it's important to protect public health, safety, and welfare, to protect public interests in the public right-of-way, to protect private interests adjacent to and within the public right-of-way. Urgency ordinances go into effect immediately upon your action, and it does require a 4/5 vote, which means that tonight it is vital that all of you support this idea or it would not pass. Now, that's the overview. Now I want to get into a little bit of the nuts and bolts of this. What staff is suggesting, and again, we've given this extensive thought, had extensive discussions. We are recommending that these applications be processed without public notice, hearings, or appeals, because that is the only way to feasibly meet these new federal standards. We cannot follow a normal process and still process these from application at our counter to issuance of building permits in 2 or 3 months, respectively, for facilities on existing and new structures. This is how, as I just mentioned, we've been processing the 6409 requests since 2012, but these are not comparable to 6409. This is a different class of facilities, as you just heard, in terms of volume, height, etc. Now, given that process, staff is recommending that the city engineer be given the ability to approve these facilities in the public right-of-way, because that director or his designees are most familiar with all of the various improvements and interests in that physical area, which we do anticipate will be the majority of applications, and that the Community Development Director would have approval authority over such facilities proposed outside the right-of-way. They could be on a building that's adjacent to a public right-of-way, for instance. We have included in your materials in the resolution policies that we think give us the most control possible over this new class of facilities given the FCC's ruling. One is that we include locational preferences, so from most to least preferred, we have a hierarchy. We prefer that these be located in non-residential zones, for example, or the corresponding specific plan designations that are non-residential. If it's going to be in residential, we prefer that these be located 250 feet or more from an area, a structure approved for residential use. And then if it's within that area, that the applicant has to locate it as far as possible from any nearby residential structure. And if an applicant is proposing something that does not meet this most to least preferred hierarchy, then we are asking for a clear and complete analysis of why a facility cannot be located, for instance, in non-residential zone compared to a residential zone. Again, trying to give the city the most control we can have over these types of facilities. We also have a hierarchy of structural preferences. So as shown here, staff's most preferred location is a replacement streetlight, as illustrated to the right here and as in the previous photographs. A new streetlight with an antenna facility on it would be the second most desirable. And then on down the hierarchy to a replacement or new traffic signal, a new non-replacement pole, which is the same as a monopole. And then our least favorite option is a wood pole. And it's our least favorite option because you can't hide the wiring and a lot of the related equipment inside a wood pole, as you can on other poles. We are identifying certain structures that we are identifying as prohibited structures, including decorative poles, such as this example from Thousand Oaks, on signs, utility poles that are scheduled for upcoming removal, and again, new wooden poles are would not be allowed under this approach. Aesthetic requirements, as I mentioned before, the FCC is looking for objective standards. So we are developing those as we speak. The new aesthetic rules go into effect next month that were enacted last year by the FCC. But if you look to the right of this image, this is actually a prototypical design that was developed by Public Works staff. And as you can see, it would have a replacement pole, a replacement street light, and then some type of a structure on top, hopefully a shroud or something comparable. Again, this would be about 30 feet. It varies depending on the plate that you're referencing. And then these radomes tend to be about 5 to 6 feet in height and about 12 to 18 inches in diameter. So this is a prototypical design that we have recently developed with the idea that if a wireless carrier wants to go in a certain area, we would encourage them to adopt a comparable design or something that's even less obvious. We also, in your resolution, I won't go through all of this, but we have standard conditions, which again are part of our effort to make sure that our standards are known to the wireless companies ahead of time. Everything's online. They can now look at those through our code and the resolution and understand the city's position. One of the most important of these standard conditions that we go through on all facilities proposed in the city is that they always have to meet the FCC's RF standards. That involves a technical analysis by an RF engineer. Dr. Kramer's firm reviews that report to ensure that it's accurate and comprehensive, and that will continue with these new standards. So this pie chart is intended to show sort of the wireless policy framework that we're looking at. Again, City Resolution 97197 we've used for many facilities in the city. It's not going away. It's still there, most applicable to, again, macro sites. We have the 6409 rules for comparatively small changes to existing facilities. We've been implementing that, meeting the 60-day clock, and that would continue, but it would be formalized through the resolution and ordinance before you tonight. And then the third piece of the pie is this new FCC Rule 18133 piece. And again, our approach is to, in full recognition of federal law, to exercise as much local control as we can over this defined group of wireless facilities that are intended to accommodate 5G technology. So with that, staff is, again, recommending that you adopt the urgency ordinance tonight that would go immediately into effect, adopt the corresponding policy resolution, and then also adopt the resolution that would initiate the regular ordinance that we would then take through Planning Commission and bring back to you in the future. And with that, again, I'd be happy to answer any questions as would the other team members here tonight. Thank you.
Thank you, Mr. Town. Dr. Kramer, it's good to have you with us. I want to start out with the questions. Typically, I let the rest of the council speak first, but I'm curious. I've heard talk that by 2030, with this 5G and driverless cars, and that a third of the workforce a third of the jobs will be lost through automation, whether it be transportation or delivery drivers or cashiers. Is this why there's a push at the federal level for this idea of automation? And with all your insight, can you share that?
Flying cars.
Flying cars, is that?
Yes, we're supposed to have flying cars now. Let me simply say that the FCC's rules, not one place in them do they specify 5G. Do they require 5G? Do they require 4G, 3G? Not one section of the FCC rules requires deployment of any new wireless facility anywhere at all, much less in areas that have no coverage, rural areas, for example. So we have to separate the rules from the talk. And the talk is very exciting, unless perhaps your job is being displaced by it. But really, this is a fundamental change in a regulatory policy that may or may not open up the door to all of these things that we hear that apparently we need, like autonomous cars and so forth. I don't know.
I'm just curious as to the urgency at the federal level that they would usurp our autonomy. I mean, this is basically thrust on us, and I'm just trying to get an answer, trying to figure it out.
Yeah, at the end of the day, I teach regulatory law and policy at Northeastern University in the doctoral program, and we deal with agencies that really have shifted their focus from public protection to promoting the industry they're supposed to be regulating, and that's what we're dealing with at the FCC.
If I may, Mayor, I will also state that if you read the exhibits that we have, the attachments that we have for this project, you will note that there is a federal statement, if you will, that they put when they want to throw this regulation at us and all the local entities across the nation, by the way, and that is, they're calling it the 5G global race, and it's to benefit Americans, and that's how they start out with their analysis for this project and this new regulation. And that's important because these regulations came into effect on January 14th of this year. There are other ones coming into effect in April 14th, which is the aesthetic aspect of it. And so we're bringing this as an urgency because if we don't have something in place before April 15th or 14th, there could be challenges. So we take what they're doing. There are challenges actually to this regulation at this point. We don't know what the status of those challenges are at this point and what's going to happen. But for now, we know that these regulations are in effect, and that's why we have this urgency, because we want to avoid unnecessary blight. We want to avoid impacts to our public infrastructure. So if we don't do this at this point, we need to. We might be in trouble in the future.
Well, just so you know, I'm in favor of you getting ahead of this. I was just more inquiring of the doctor as to the urgency at the federal level that they would be doing this, and I appreciate your answers, your insights. I'll open it up to the rest of the council. Councilmember Bill de la Pena.
Thank you, Mayor McCoy. Interesting discussion. Mr. Kramer, I know we go back, 16 years or so. We met when I was on the Planning Commission, and in the process, you've earned your PhD. Congratulations. You said that the FCC is trying to accommodate the very industry they're supposed to regulate. Did I understand that correctly?
Yes.
Okay. Given that now the cities are forced to deal with this, I'm trying to figure out, this is really kind of shocking for Thousand Oaks, because we pride ourselves on public notification, on listening to the residents, on the aesthetics, and all of that is thrown out the window with this with these new requirements. So in looking at what will change, everything will be done administratively, no more public hearings, nothing at all. But there is a little sliver of hope with the locational preferences, structural preferences, and prohibited structures. I was wondering if, and I'm personally worried about the impact it will have on residential areas, but if all of our light poles were decorative, what would the picture look like?
Under the present proposed rules, decorative light poles are not available for use as cell sites. The alternative would be that the wireless companies would install their own new poles in residential areas. Remember that in this technology range, we're looking at coverages of 300 to 500 feet per cell site in any direction. And you can imagine that the city's successful program of controlling where these are to major thoroughfares and so forth will be seriously impacted when a major thoroughfare is more than 300 feet away from a particular house. So that's a fundamental change. But in terms of the poles, there is a specific rule in the guidelines before you tonight that does not allow the use of decorative poles. Again, that's an aesthetic protection issue.
Correct. So if we wanted to protect residential areas more specifically, and I'm just asking hypothetically, specific plan designations would be the ones that we would prefer that they stay out of, the way I'm reading this? Or is specific plan designation something that you would prefer?
Well, our decorative light poles are primarily found in specific plan areas, downtown Thousand Oaks Boulevard specific plan, for instance. So those would be off limits under this approach, again, on aesthetic grounds, but we are leaving the door open for other facilities in the same area, as Dr. Kramer mentioned, a new light pole or a monopole, although that's not our preferred approach.
Yes, because it says the locations from most to least preferred. So most preferred would be non-residential zones and specific plan designations, but specific plan designations, as you say, have the decorative poles, and therefore they couldn't really put anything there.
Well, there may have been a little bit of confusion on that just in terms of the image that I used. That bullet point was intended to mean non-residential areas or specific plans with non-residential areas, not entire specific plans. In other words, specific plans are custom zoning, and if they have areas that are designated for non-residential, then we would prefer that these facilities be located in those portions of a specific plan, the non-residential portion. The overarching idea is, of course, to look at these as far away from residential structures as possible. And the first cut is non-residential versus residential.
Unless the residential light poles were or are decorative.
Well, if the residential poles were all decorative, then again, the applicant would need to consider a new pole, a new light pole, and that would be the most likely solution.
If I may, one of the important things to think about is we have to be concerned about capacity. So we're not challenged now with coverage necessarily. We're challenged with capacity. And so that capacity also includes going to the residential areas with all the residents who have iPads and telephones and cell phones and TVs, et cetera. So our goal here with having some of these objective standards that we're going to have published, so any carrier can come to our city and look at our standards and know these are some of the objective types of structures that they can build. And it's also important to note that a structure can be many things. Can be a building, can be a pole, can be a water tank, for example. So the word structure has been very carefully crafted by this regulation to include those things. And so what we're trying to do is say, if it's going to be in the right-of-way, we have some control, objective control with maybe how it looks like. And we believe staff's recommendation is we look at a street light, that's probably the less intrusive versus a monopole or versus some other type of structure that could be used. So we do have to expect, and let's be very clear, we have to expect that they're going to go into the residential areas, absolutely. But what we're trying to say is in those residential areas on a street, we want to have them on locations that are farthest away if possible from the residents themselves, if that's possible. And the next thing, one of the things that we're asking for in our policy is in the right-of-way, we're asking that if they have equipment other than the antennas, that they underground those. Just like any utility would be on Teal Boulevard, we would have them underground like any other type of utility. They're getting the right to be in the right-of-way without question, so we're going to have them act like another utility and do that undergrounding. Now, there might be new technology that avoids that for them. Absolutely, that might be true, and we'll have to look at that objectively for when they come in with these applications. The other concern we have is, and it's important to remember, if you go to page 3 of your staff report, there are very, very specific constraints that local entities have when it comes to these things. And one of them has to do with the RF emissions, and that still is on board here. We cannot challenge that in any way for the local entity. What we have Dr. Kramer do and his team as our consultant is when we get an application, we have them evaluate to ensure that the minimum requirements by the federal government in regards to the RF emissions are being met. And if you would like to, Dr. Kramer can certainly give you an example of how those are measured and how we are protected and how the federal government looks at that. But it is important to note that's just one example of how they're constraining. This new rule, Regulation 18-133, it adds additional constraints now to how we're reacting to these wireless facilities. And again, these are mainly going to be small wireless facilities in the public right-of-way because it's less expensive for them to go into the public right-of-way than into private, for example, where they have to expend more money and probably have a higher lease rate.
Thank you for the explanation. I appreciate your coming up with this staff report and the urgency ordinance. We seem to have no choice, and it will be a bitter pill to swallow for the residents of our city. Thank you.
Thank you, Councilmember. Councilmember Engler?
Yes, thank you, Mayor. We don't have a large audience here today. I hope there's a lot of people looking at this at home because, in effect, this is the public hearing on a lot of structures that are going to be put into town. Give me a good idea, because the range of these antennas is 300 to 500 feet. We have 58 square miles. I mean, we're talking a lot of poles that are going to be having these devices put on them. Is that a good assumption?
I speak at a lot of wireless industry conferences, so do my partner, because under the Godfather rule, you keep your friends close, but your enemies closer. And currently, what I hear RF engineers at the conferences say is that they're looking at about 60 small cells per company per square mile. Let me kind of pencil this out for Thousand Oaks. And let me be ultra conservative. Instead of saying 55 square miles, let's just do the residential area, roughly about 40 square miles in the city. And instead of saying 60 cell sites per square mile, let's only use half of that, 30. We have 4 wireless carriers. When you do all of the math, you come up to somewhere around 4,000 to 5,000 new cell sites over the next 5 years in Thousand Oaks alone. Is that realistic? Do we really believe that's going to happen? I'll give you an example. Since these rules went into effect in January 14th, another city that we work with, this is public record, so I have no problem sharing with it, it's El Monte. They're only 9.6 square miles. They've received over 70 applications for small cells in about almost 6 weeks, less than 6 weeks. So the build out is going to happen. It will move here, and that's one of the reasons why staff is very concerned about getting these rules adopted so that before the rush hits here, and it's normal to go into the metro areas and then grow out from there, we want to have the rules in place. But you're looking at thousands of cell sites in Thousand Oaks over the next 5 years compared to what is effectively a handful of 160 some odd cell sites now, 140. So that's the magnitude, that's the order of magnitude, council member, that we're looking at.
Thank you for that. I think it's important for people to know that there's going to be a visual impact with these on practically every corner. And there's not, my understanding is that we don't have a whole lot of say that this will be coming. There is some benefit, and I think Mayor touched on it a little bit. There are some benefits to 5G that might be out there that are exciting for a lot of people.
Or frightening.
Or threatening. There's always a two-edged sword. But there will be an impact in our town that really we're going to be giving staff the ability to approve most of these. There just won't be time to do a normal planning process. So we have to do this. I agree 100% with the undergrounding of the controlling boxes. That seems to be a more visually impacting item. But there's not a lot that we can say. I agree with Council Member Bill De La Pena. We don't have a whole lot of say in this. Nope. So let's try to make as good a deal as we can.
Well, if there's no other questions from the council, we will come to public comments. We have 2 speakers tonight on this issue. Our first speaker will be Arijj Rajput. Thank you for staying with us through the evening. Welcome.
Can you see me over the podium? Okay.
Yep.
Good evening, everybody. My name is Arijj Rajput. I am here on behalf of the California Wireless Association, and it seems we are not that popular lately, but I understand the city's concerns, and I have read the ordinance, but I'm just here today to ask for maybe a continuance on this item, or to allow CALWA a little bit more time to do a comprehensive review and actually sit at the table with the city and the city's consultant to work together on an ordinance, bring about our concerns here and address those specifically, and especially with some of the concerns that I heard at the city today. So we essentially would just like more time to be able to do that and work with the city and with TLF as well.
Okay, we'll consider that.
Thank you.
But thank you for coming out. And then our next speaker, Bill Lind. Thanks for coming out, sir.
Thank you. Yeah, good evening, Mayor. Good evening, City Council. There have been powerful cell towers deployed around California lately in more numerous amounts, including in Northern California. These close proximity microwave radiation antennas, called small cells, are mounted on public utility poles and light poles in the public rights-of-way. Some are within 100 feet of homes, and most importantly, they can be hazardous. Established science proves that exposure to wireless radiation can cause neurological illness, DNA damage, heart problems, reduced fertility, and increased rates of cancer. These transmitters can be so close to our homes, they're a potential violation of a guaranteed constitutional right to privacy. Once the pole is claimed by the carrier, they can increase the power, the height, the width, and swap out equipment without review. This is happening without knowledge or consent already in communities in California. California cities such as Monterey, Hillsborough, Mill Valley, Ross, San Anselmo, Petaluma, and Sebastopol have already rebuffed Verizon and passed local wireless and zoning ordinances to protect their residents. I have included a attachment in the city of Petaluma. I'd like to give the council and the mayor to review and compare it to your proposals for your ordinance changes. Currently, the city of Simi Valley is in the process of reviewing the same issues, by the way. This needs to be done no later than April 15th, after which a window of opportunity closes. We lose the ability to use the aesthetic standard before the FCC report and order. Another step I'd like the city of Thousand Oaks to consider is to join the appeal lawsuit process that Marin County has joined with municipalities against the FCC regarding these new cell phone technologies, new cell phone towers that the recent ruling had adopted. The county is taking the legal step to protest the federal government's seizing of local control on the deployment of future technologies, including 5G, and how implementation costs can be recovered. While local governments have always been preempted from regulating based on radio frequency radiation concerns, local governments have always been able to regulate neighborhood aesthetics and other safety matters. The new FCC ruling starts to handcuff severely traditional areas of local regulation with new time limits and constraints, as explained by your staff. There's an inconvenient truth that carriers don't want the city to know about. It is called fiber optics, which is safer, cheaper over time, private, and won't affect property values. Is also more energy
Mr. Lynn, you're going to have
efficient.
to put a caboose on the comment train. We're running out of time, but
Okay.
please give us your
Make
conclusions.
sure whatever you enact that your 250 solution is better than a lot of other communities are adopting or considering to adopt. So please adopt that 250 solution in your ordinance. And also, if you don't make sure that excellent aesthetic ordinances or upgrades to the ordinance are done, your property values will decrease sharply, as seen in towns like Sonoma and Petaluma. This big push from the FCC and the current administration to speed up cell phone process networks, all it is just a push in order to get ready for 5G without regard to safety, the environment, or privacy. Thank you.
Mr. Lynn. Thank you, sir. Councilmember Adam?
For Mark or Dr. Kramer, one of the speakers just suggested a continuation. However, this is being presented to us as an urgency ordinance, and we are on a time frame here. And as you say, we want to get ahead of what could be an inundation of permit requests for small cell wireless. So a continuation would seem to me to not be
Councilmember Adam?
advisable.
Absolutely, you are correct. Our recommendation is to move forward with this urgency ordinance tonight. We are reacting to this
The
federal
FCC.
regulation, and we were given deadlines. January 14th, it became effective. We have hired one of the premier experts in the nation to help us draft this ordinance, and our first obligation is to protect our city with this urgency ordinance. Certainly, staff would be happy, as we always do with any project, that we would meet with any of the stakeholders and meet with them. We have a resolution for initiating a second ordinance that goes through the standard process as a precaution, but we will be happy to meet with them and talk to them, have the meetings with them, absolutely we would do that. But tonight, our recommendation is that you move forward with this urgency ordinance. It is imperative that we do that to protect our city's values and infrastructure at this time. And the next thing I would like to do is have Dr. Kramer talk to you about the RF emission comments from the second speaker.
Before I do, a bit of framing. I've been working for the city continuously as its technical advisor for 32 years now. So essentially every wireless project that's come into the city has gone across my desk at one point or another. So I want to also follow up on what Mark just said about, or Patrick just said about the fact that we can do both. In fact, we're the ones who actually sent notice to the California Wireless Association of this meeting tonight. I presume they're here because of the notice that we sent to them, because we wanted to make sure that the industry, as broadly as possible, had the opportunity to participate. That said, the participation process that Patrick's laid out makes the most sense about adopting tonight and then going through the regular process. So we can accommodate CalWA's request, I think, very comfortably. That said, I'll turn to the other comments that have come in. Most notably, the public is concerned about radio frequency emissions. I know several of the council members have heard me talk about this in the past, but if you'll indulge me for a couple of minutes so that the public at home who's watching this tonight can get a better sense of what's going on, I think it'd be worth it. Back in 1996, the Telecom Act was passed by Congress. One of the provisions in it required the FCC to develop national standards for RF emissions. Prior to that time, local governments could set their own, and there was a patchwork of standards around the country. The FCC took on the task in 1997 and went to public radiological health officials, wireless industry, the military. They looked at standards in other countries, and they came up with a standard for the U.S. The standard for the U.S., by the way, is based on a couple of things. It's not a unitary standard. It reflects the fact that we as people, big bags of water, if you will, absorb certain frequencies more efficiently than others. So the FCC even took that into account. And at the end of the day, they created a standard that had a safety margin built into it. I'm going to use, as a college professor, I think I'm allowed to use a visual aid to explain what that safety standard is. I have a 12-inch ruler. Assume at the top, that's the point where you can actually measure some effect caused by RF, and it's heating. It's not a DNA change. These are non-ionizing emissions, just heating. So the FCC had to set its national standard for public exposure 24/7, somewhere between 0 and 12. We know they didn't set it at 0 because that means there's no emission. We know they didn't set it at 12 because that's the point where you can actually measure some change. So on this scale of 0 to 12, where did the FCC set its standard? 0.26 inches. And as it turns out mathematically, that means that there's a 50 times 50 safety margin between the maximum we can be exposed without even knowing it and the point where you can actually measure an effect from that exposure. Now, that's the technical part. Let me switch now to the lawyer part, which is this is an area where the FCC completely occupies the field. They are the sole national agency that sets these standards. We can't even adopt the FCC standards as our own. So the question is, and this is in the Telecom Act, this is in the FCC rules, and this is even at state law. The question is, does a proposed project comply with the FCC rules? If it does, then legally, that's as far as we're allowed to take it. There are certainly very thoughtful public concerns about the effects of RF, but at a local government level, like here in Thousand Oaks, we're not allowed to nullify a federal rule. So at the end of the day, one of the things, as you've already heard, that we do, our firm, is we evaluate whether the applicant's project will comply with the FCC rules. And interestingly, there are some times when they've proposed projects that don't. So we've caught those. But I can tell you that the city of Thousand Oaks historically, for a long time, decades, has evaluated compliance with the FCC rules as a threshold standard for approval, which is far more than virtually, well, most other cities. They don't have the technical expertise to do that. So that's kind of the long and short. That's how we got here. That's in terms of the safety margins that are built in, a 50-time safety margin. That's what we're allowed to do legally and what we're not allowed to do under federal, state, and even congressional law. So that's kind of the tour of RF safety. If you have questions, of course, I'll happily answer them. But that's kind of a broad tour of the entire subject. Finally, I think there was a comment about joining the lawsuits. I can tell you that our firm represents the League of California Cities, the League of Oregon Cities, and the League of Arizona Cities and Towns. We filed in the Ninth Circuit to challenge these rules. But at this point, these are the rules that are in effect, and we must follow them until the courts tell us that either they confirm the FCC and say, yes, you got to continue to follow it, or they say no. But we're deeply involved in that process, representing effectively 1,000 jurisdictions, including Thousand Oaks.
Very helpful. Thank you, Doctor. Councilmember Bill de la Peña, did you have a question?
Quick question regarding the leagues, California leagues and Oregon leagues of cities. You are representing both. Did you mention a third entity?
The Arizona League of Cities and Towns.
Okay, so all three of them. So would you then advise a city like Thousand Oaks to join other California cities that are suing individually as part of amicus brief or anything like that?
That's his question.
Oh, okay.
I would certainly hold off, and if we want to have that discussion, we can certainly bring it in a proper arena to discuss. I think it's important to note that the regulations, as Dr. Kramer has said, the regulations are in effect right now, even with the lawsuit. That's very important to note. The April 15th date is on the horizon, 14th. It's on the horizon. It's very important to note that we have to, that's why we're doing this urgency. And one of the concerns we have with the federal regulation is there's a lot of definitions and vagueness and broadness in some of the terms. And part of the lawsuit, I think, is to try to get an understanding of what those terms mean, because it leads to problems when people or agencies have to affect that.
One thing, just Dr. Kramer, you can probably confirm this. In your representation with the California League of Cities, did you say that the league is filing an amicus brief?
Actually, the league is part of the active lawsuit.
Okay.
We're actually a party.
Right.
Thank you.
Councilmember Adam.
Well, thank you very much for the informative presentation. It's good to see you again, Dr. Kramer. I was on the Planning Commission when you would come to speak to us, and we had a lot more latitude back then than we do now. But it's clear to me that this is urgent, and that's why it was presented as an urgency ordinance, and that we do have an April 15th timeline. And the rules are the rules as they stand now. The League of California Cities may be able to change that, remains to be seen, but we've got to deal with what's in front of us. And I do want to commend staff for coming up with every opportunity possible within this framework that's been giving us to protect our citizens, protect the aesthetics of our community and the health of our citizens. We're going to do everything possible to make sure that we make this as aesthetically pleasing as possible. But, you know, there's a race to get 5G in this country, and the FCC's behind it, and AT&T, Verizon, T-Mobile, Sprint are all going to be part of that race. As you mentioned, the one community that had, 70 applications in the first 6 weeks?
Yeah, El Monte, 70 applications in a 9.5 square mile city.
Yeah, so we're going to get quite a few. So this, in other words, this is an ordinance we definitely have to, in my opinion, pass tonight. So I would like to move that we do, in fact, pass the staff recommendations for 9D, the urgency ordinance and resolution amending the regulations and policies related to wireless communication facilities.
Recommendations 1, 2, and 3. Is that correct?
Correct. 1, 2, 3.
Ms. Rodriguez? You needed 4/5. Looks like you got it.
The motion carries 4-0 with Councilmember Jones absent, and I do have an ordinance title to read into the record. Urgency ordinance adding Article 44 and amending Section 9-4.202, Section 9-4.214, and Section 9-4.2105 of the Thousand Oaks Municipal Code, regulating wireless communications facilities pursuant to applicable federal laws, ordinance number 1661 NS.
Thank you very much. Just to be clear to all the folks out there, tonight we were trying to get ahead of the mandates from the FCC, and we want to maintain, to the best of our ability, our autonomy and maintain the beauty of our city, and everything that we did tonight was for that purpose. So however you feel about 5G and these towers coming in, that's a federal issue. Take it up with your Congress member. But here locally, we are implementing this in order to protect what we consider to be the beauty of our city. So thanks for all your work. That concludes item 9D.